about the directors' independence and directors' duties in the U.S., but that obviously ties into comparisons with the UK and India and some of the stuff you've been looking at, the nominee director idea, which I think is legally similar in the US, but the factual background is very different, the way companies are set up in India versus the US. So you'll see as I go through it, the kind of widely held public company without a controlling shareholder is the dominant model in the US. Although in recent years, the controlling shareholder, the Elon Musk, who has power over the company, even though maybe not a majority of shares, but control, and Mark Zuckerberg is the same, has become a bigger issue. But I think that's, as I understand it, similar to the way India's been for a longer time, where you either have a majority shareholder or a controlling shareholder. So in some sense, we're just now looking at some of the issues that I think you all have thought about for a longer period. And the other movement in the US, so there's been a little bit of a movement toward private ownership or private control, and toward what's known as the dual share companies. And that's the Mark Zuckerberg model, where he doesn't own a majority of the firm, but he has a majority of voting power. And you know, if you look at like recent IPOs or recent companies that went public, like Snap, this has been a big thing where we want to sell shares, but we don't want those shares to have full voting power. We want the founder, the creator, to have the power to make the decisions, because maybe they have a vision for the company. So that's been a big new issue in the US, and it ties into some of the basics I'll talk about. But as I said, I'd love to have questions as we go, because I'm going to start high level and then get a little into the weeds here and there, but I'd love to hear comparisons for what you all thought about. So if you have the slides, you know, there's the intro. But I'm now looking at the second slide. These are pretty basic kind of slides to guide us through. As I'm sure you know, the U.S. has this question of directors have duties. The two questions are, what are those duties and who are they? To whom are they owed? The very simplistic view is there's a duty of loyalty and a duty of care. The duty of care says you're supposed to do your job well, not negligent or lazy or sloppy. The duty of loyalty says you're supposed to try to benefit the person to whom you owe that duty, not yourself. You're not supposed to be conflicted. You're not supposed to steal opportunities. You're not supposed to do things that help you at the expense of whoever it is you owe that duty to. Now, the general version of this, which I'll talk about in the next slide or two, is you owe that duty to the shareholders. Although that's a complicated statement that I'm going to unpack a little bit. Among these two duties, the duty of care is pretty pointless. I mean, in the sense that it's unenforceable. So the business judgment rule makes it very difficult for you to sue a director to say you violated your duty of care. You really have to show that they just didn't show up for the job. So now that doesn't. I say it's pointless in that sense in court. Some people say it's great because it still tells us most directors want to do their job. So it tells them what their job is, so it's a guide there. And there are places in the law where it comes in, but the really important thing is the duty of loyalty, because that, if someone violates, they're not protected from. If you sell something to yourself when you're running the company, if you buy something from yourself when you're running the company, and you don't get it cleared and it's not good for the company, that's a violation of the duty. Again, this is all, I'm sure you know all this, I'm just kind of building up to some of the finer points I'm going to get into. That next slide is out of, I'm missing this slide. Let's see. Hold on one second. So I'm missing one slide. So there should be a next slide that says, to whom is the duty owed? And I know this was a question you all are thinking about. All right, so when I think about the who, as I said, the basic idea is the shareholders. But there's a movement that says, no, it should be owed to the stakeholders. And what does that mean? Is that the employees? Is that the customers? Is that the community. And there's a large movement to say that that should be the focus of the director's duties beyond just the shareholders. The truth of it in practice is directors are running a company. They're never just thinking about the shareholders. And there's no, like, if you said, I chose not to destroy the world, but it hurt my shareholders a little bit, no one would sue you for that, or they would lose, right? So, like, there is a limit on your duty to the shareholders, even in the statement that it is to the shareholders. A lot of times people think of the easy way to view it as your duty to the corporation to maximize its value, and you have to take into account all the different factors into that, which gives you discretion to say, you know, I don't want to do something that harms the environment. Or, you know, a great example was CVS is a pharmacy, and they said one day, we're not going to sell cigarettes anymore. They said in the short run, that's going to lose us money. But in the long run, we think it's better for the corporation as a whole. Because that duty of care duty is so weak, and this is a good thing about it being weak, they can do that. No one's going to be able to sue them for making that choice. We have a long-run view that it's better for the corporation as a whole to lose a little money in the short run and do something like not sell cigarettes because we want public health. We are, after all, a pharmacy. Now, if they did that to benefit the directors or the CEO themselves, that'd be a duty of loyalty, different problem. So I always think of the baseline is you have a duty to maximize the value of the firm within reason, and you get to decide, make reasonable decisions about whether or not you're going to sell this product or that product, and you can think about broader stakeholder values when doing that. All right, that's the basic baseline. And I know some of the questions you had, well, what does it mean to have a duty to a stakeholder? Can you then consider your own interest or whoever perhaps nominated you or particular shareholders? So before we answer that question, then I want to go into independence and kind of conflict questions, what it means to be a director and when it really matters. Okay, so so if you go to, if you go to slide, the sixth slide in the slideshow. So on this slide, I lay out this kind of flow chart of a controlling shareholder case. So I wanted to start with controlling shareholder because it plays into the nominee director, and it kind of opens up the question of where the owner can exercise their power when thinking about these duties. So the first question is always, is the person a controlling shareholder? And in the US, we have this weird kind of non-rule standard that says, well, if they have a certain amount of control that makes us think they can call all the shots, then we'll deem them a controlling shareholder. If you go to slide 5, this is an excerpt from a recent case about Tesla. So I mentioned Elon Musk before. So Elon Musk has been sued, and Tesla's been sued a lot lately for decisions he made, saying you're a controlling shareholder, and you didn't run this through independent directors. You made a decision that helped you as a controlling shareholder. So remember, we said that the directors have a duty of care and loyalty. But the directors can be controlled by a shareholder, and then because that shareholder can control those directors, that shareholder now has the same duties or similar duties. So then we say, well, are they in control? Elon Musk does not own 50% of Tesla, but he owns 20-some% and has a lot of control. So in the Tesla case, there's this quote that I always like where there's Tesla quoting another case. So they say, in Pure Resources, then Vice Chancellor Stein aptly described the controlling stockholder as an 80-pound gorilla whose urgent hunger for the rest of the bananas is likely to frighten the minority shareholders who would fear retribution from the gorilla if they defeated the merger and he did not get his way. Chancellor Allen called controlling shareholder transactions the context in which the greatest risk of undetectable bias may be present. What does that mean? If you're Elon Musk, everyone's afraid of you because you're the boss. And even if you don't have 50% of the shares, they know that you make the decisions, that everyone looks to you, and you can take them off the board. And so if you say, I want to do X, Y, or Z, people are going to go along with it. And Chancellor Allen's point about it being undetectable, right? It's not so easy to say, is this decision good for the company or good for Elon Musk? And he might not even know. He might be conflicted and not even realize. And so if everyone just nods their head and does what he wants, you're going to have him doing things that benefit himself, perhaps unintentionally, but also intentionally. So we want to say, if they exercise enough control, we're going to step in and say, you're subject to a higher standard, and this is a potential duty of loyalty violation. Now, just because you're a controlling shareholder doesn't mean you can't do anything. It just means what you've done has a conflict. And now, the way the U.S. law works is you don't get that protection that the duty of care had. You've got to prove that what you did was entirely fair. Because you were a controlling shareholder, you did something, it might have benefited you, and especially when you're doing something that involves your pay or that you have an interest in, you've got to show that it's entirely fair, which is a hard thing to do because that requires basically a trial where you're going to go through and show that everything the company wanted, they got, everything that was good for the corporation, was part of the deal. Now remember, I said the easy way to think of the duty is not the shareholders or the stakeholders, but the corporation. And most of the litigation plays out that way. Did this benefit the value of the corporation? Which of course indirectly goes to the shareholders, unless the company's insolvent, which I'll come to near the end. There's one exception, there's a way out of this. So you say, wait a second, if every decision a controlling shareholder like Musk or Zuckerberg makes is subject to scrutiny in a trial, the company can't do it. And there'll be lots of transactions that might benefit them that will then lead to the standard. So, and this was the slide, this is the third slide, we have safe harbors. So the court says there are ways you can do things that cleanse a transaction. And I should stop. When I say the court, I mean the Delaware Chancery Court and Delaware Supreme Court. In the U.S., most large corporate law is made in the state of Delaware. Small local firms might have their local corporation law, but most large firms are Delaware. And it turns out, like, I'm in Illinois. Illinois corporate law mirrors Delaware a decent amount. So if you're a small company in Illinois, that would be your law. It's kind of like Delaware. But if you're Facebook, Tesla, you're following Delaware law. So the courts say you have a safe harbor that gets you out of entire fairness review, even if you're a controlling shareholder. And so the case that established this most definitively was this in re NFW, and they said a shareholder vote plus a committee, and the plus is important here, will get a controlling shareholder merger about business judgment rule. That's what when it says BJR, that's what it means. Now later cases have said, yeah, that's the rule, not, and the Tesla cases have said, that's the rule not just for mergers, but for all transactions where the controlling shareholder might benefit from the transaction if they're on both sides. So what do we mean by a shareholder vote? Cut down here to slide 7. And actually, go to slide 8. Slide 8. So here we lay out the safe harbor more kind of broadly. After MFW, some follow-up cases, they said it applies to controlling transactions, the controlling shareholders on both sides. All right. If you have a majority of minority shareholders, that is, the shareholders who do not have control, if a majority of them vote for whatever it is, and the second bullet point, you have a well-functioning special committee of independent directors. Get both of those, you get business judgment rule. So you say to the shareholders, is this okay? A majority of the non-controlling ones say yes. And the committee had recommended it to them and said it was fair. And you have to have both. If you only have one, it's a minor, what we call burden shift, which says when we have the trial, the controlling shareholder now wins a tie. That's all you get if you have one. You still have a trial about whether it was entirely fair, but if it's a coin toss whether it was fair, then the controlling shareholder wins. If they don't do any, the plaintiff, the shareholder suing, wins a tie. That's not worth much to a director or a controlling shareholder. So you want both. That's what you get if you have a vote plus the committee. So that's you're Elon Musk and Mark Zuckerberg, your shareholder with 60% of shares. You want to do something that might benefit you. You've got to set up a committee of independent directors. You've got to have a shareholder vote where the minority, the non-controlling shareholders, the majority of that group votes in favor. Then you get business judgment rule. And as I said before, in a court, if you've got business judgment rule, you're almost certainly going to win. All right. That brings up a very kind of interesting question, which is who's independent? And then the other question I mentioned earlier was, what does it mean to be in control? And one second. I sent you the draft slides, so you have got a ton more slides than you're supposed to have, which are from my class. Where did the? Hold on, I apologize.
Yes, we have the one with 91 slides.
That's not the right one. That's not correct, which is why there were slides missing. Okay, I'm going to send you a new one. Well, I'll keep going, but I'm going to send you a new one. If you can send it to the students, you should delete the one you have. It's just a bunch of. What I did was I compiled all my various slides for the presentations and started filtering it. I apologize for that. So here we go. The actual one. I had the right one open, but I sent the wrong one.
Riddhi,
Okay.
can you please log in and send, because if I would, my email account is going to be visible on the screen recording. So just the end-user's ID that professor is sending it to. Just see the sent email last thing with professor's slides and just add this new attachment.
Did you get them?
Yes. Okay. Riddhi, I think professor, she's just going to take a minute to log in to this account.
Okay, sorry.
And then yes. Suman, could you please drop in your ID because you joined slightly late, that you were not there in the list of recipients for the slide. So Riddhi is going to add you also.
So while that's going on, so when you open the new version, you'll see slide 2 has that where I say duty to whom or what. I list the potential your shareholders, creditors, which we'll talk about, corporation itself. Then I go to controlling shareholder. All right, so here's the slide I realized something was missing. All right, who controls? As I said, Delaware has this non-rule standard. But in the recent cases, and this is where Elon Musk has been litigating Delaware and been important, they said he was controlling. So I'll read you the quote. It's in slide 4. So Delaware courts will deem a shareholder a controlling stockholder when the stockholder owns more than 50% of the voting power of the corporation or owns less than 50% of the voting power of the corporation, but exercises control over the business affairs of the corporation. Now, what does that mean? So you go to the next slide and they go on a little bit. They say the plaintiff may plead either or both of the following. That the minority blockholder actually dominated and controlled the corporation. So they say, look at what they did. They controlled the corporation. They controlled the corporation, its board, or the deciding committee with respect to that transaction. So look at this transaction. Elon Musk forced everyone to go along with it. Or that minority blockholder actually dominated and controlled the majority of the board generally. They always do what he wants, right? Now he's the controlling shareholder. Now, I wanted this slide because I think it shows a contrast with what you were looking at with the nominee directors, where you have like a family trust or someone who owns the majority. That's an easy case. But these are cases where they own 20%, but they still have control. That has been the big litigation point in recent years in Delaware. Like, where do we draw that line? And then slide 6 in the new version shows you that quote I had about the 80-pound gorilla. All right, in the new slides, slides 7 and 8 are the ones I was talking about, where we have the safe harbor. You get the majority of minority shareholders. You get a special committee of independent directors. Then the really interesting question is, who is independent? And this is particularly interesting in the U.S. because it keeps changing. And when I started teaching in 2011, the answer to this question was fairly easy. Was you've got to show a real financial interest for someone to not be independent. That was kind of like, maybe something slightly less was okay sometimes, but you basically needed the director who was claiming to be independent had an investment with some other fund that Elon Musk owned, or some, financial benefit. Over the years, that bar for lack of independence has lessened. It's become more easier to show, no, there's a little bit of a kind of friendship relationship that might make this director less dependent. And people used to call something like structural independence or structural dependence, which is, if I work for the company and he's my boss and he put me on the board, not really independent. That wasn't always enough to get you a conflict, but it is enough to make you not independent to approve a transaction as a special committee member. And that's where it's become really important, where the courts have said, whether you yourself have a conflict is one question. Whether you yourself are independent enough to clear someone else's conflict is another question. And you need to be really independent to be the one who can make the controlling shareholder or other directors conflicted transaction to say it's okay. You need to show that you're not the person's best friend. And there are cases, you can't be their cousin, you can't be someone who they named a building after when they donated money to a university. So the shareholder donates money and says, don't name it after me, name it after my friend, who's also the independent director who I want to clear my transactions. That's not independence. That's a recent case. If you look at slide 10, that was the issue in what's called Marshall v. Barnhart. Now, the independence question comes up in the controlling shareholder context, and then in another context where we want independent directors to say, after the fact, you can't sue the conflicted directors. It's what's called a special committee in a derivative litigation. That Marchand is that. And so if you look, there's the quote, it quotes Oracle about human nature. They said in those cases, you need really good independence. But recently, that standard is applied to the special committee approving and controlling shareholder transactions as well. And so we're getting this where you really need to be really independent. I like these quotes because they show what the court is thinking about. This is a very 2019. They quote Oracle, which was an older case, and it said, Delaware should not be based on a reductionist view of human nature that simplifies human motivations on the lines of the least sophisticated notions of law and economics movements. What he's saying there, that was then Chancellor, later Chief Justice Leo Strine. It's not just finances that draw people into conflict. People do things for their friends too, not just for money. So then another quote, close friendships of that duration are likely considered precious by many people and are rare. People drift apart for many reasons, and when a close relationship endures for that long, a pleading stage inference arises that that is important to the parties. Your good friend, we will assume, will do things to help you because that's what people do. Therefore, your good friend can't be the one to say you didn't do anything wrong or wasn't a conflicted transaction. And another quote, so those two quotes were in Marchand, the Delaware Supreme Court in 2019. In Oracle, another statement that I always kind of point out, which is a nice statement, is, corporate directors are generally the sort of people, this is slide 11, are generally the sort of people deeply enmeshed in social institutions. Right? These are important people, and I think this is going to be familiar to what you all are thinking about. They are important people playing in the same network of other important people. Some things are just not done because they all know each other. In being appropriately sensitive to this factor, our law cannot assume, absent some other proof, that corporate directors are, as a general matter, of persons of unusual bravery who operate heedless of the inhibitions that social norms generate for ordinary folk. So if you think about, independent directors are usually CEOs of other companies or owners of other companies, and they all know each other. And if you're on a board of one company, are you really going to accuse the CEO or the majority shareholder of insider trading or fraud or embezzlement? Because they might be on your board somewhere else, and you might not be invited to the fancy art shows and charity events anymore. And that's what he was talking about. Like, we need to think about that. And I think that's a true human fact across jurisdictions that people are thinking about. And in the U.S., you're thinking about mostly public companies and CEOs from all these different companies. But we're moving toward the Zuckerberg Musk control. But in the UK and India, I think you have more privately owned or more large shareholders, and they're going to be in an even more tightly knit community and know each other in a way that affects their views of each other. All right, so that's what I wanted to start with, like this background. Like these are the really hot item issues in Delaware litigation right now, because most lawsuits involve controlling shareholders, because that's where you can show a conflict, and it can be hard to get that independence, that clearance. So that's been litigated a lot, and that plays into some of the issues that I know you were talking about, like a nominee director. So if we think about in the U.S., it used to be that we assumed just because someone chose you to be a director didn't mean you were conflicted. So if Elon Musk says, and he really basically chooses all the directors, even the independent ones, he says these are the slate that we should elect, and they get elected, that almost always was assumed not to be a conflict. But see, now the flip side of that is they're not allowed to say we're doing things just for Elon Musk, right? So we're assuming you're not doing it, and you're not allowed to do it. And that is the baseline for a long time. In more recent years, it's still true that because someone says, this is the director I want, that doesn't conflict the director. But if they have other relationships, it might. But in the background of all of this, and this is related to the article that Professor Garg sent, in the background of all of this, you're not allowed to say, I was put on the board by Musk or by Zuckerberg or whoever, therefore it's their interest I'm taking into account. And in some sense, if you have a relationship with them, not only are you not allowed to give special treatment to them, you have to go out of your way not to favor them, to get a special committee if it favors them. So an independent director nominated by Musk with no connection has to consider everybody's interest. And Musk is one of the shareholders, has got to consider everybody. You can't favor anyone. One who has a relationship with Musk, because he's been his right-hand man for other companies, has to get a special committee if he's going to do something that might favor Musk. So that draws a pretty stark line of what they're supposed to do and what they assume. It's really, again, if you're a director and you want to make sure you stay out of trouble, look at the value of the corporation, maximize that. Now, one question that was sent was, and I know this is, you have less background on, is what about in bankruptcy and what about banks and creditors? And it gets really complicated really quickly. So slide 12, I asked the question, the duties of directors when the corporation is insolvent or in the zone of insolvency. So there are two ways that you could think of a duty to a creditor. And in Delaware, for years, there was a question about which of these was the law. So slide 13 has this. And slide 13 says, there's a shield or a sword. So what we mean by a shield is, can the director say, when the shareholder sues me, I did something to benefit the lender. You can't sue. So that's the shield version. The sword version is, can the lender or creditor sue and say, you didn't do something to benefit me. You benefited the shareholder at my expense. So there was a debate for decades on this, and the shield one was pretty easy. A director, because of that duty of care business judgment rule, and because of the idea that the real duty is maximizing the value of the corporation, a director who says, company's in near insolvent, says, I want to make a decision that will expand the value of the company, but might be better for creditors than shareholders, they can do that. The shareholder won't win that lawsuit if they say, I was doing what was best for the corporation. What does that mean? Well, when a corporation is near insolvency, the creditors have a cap on what they can get. The shareholders have unlimited, right? They get all the extra value. And so a shareholder, let's say the company has zero equity value, but it can pay off its creditors. A director could say, well, I'll take a gamble and bet all the money at a casino. If it pays out, the creditors still get paid, and the shareholders make all kinds of money. And if I lose, well, the creditors get hurt, but I'm doing what's best for the shareholders. If you decide not to do that, if you decide I will do the conservative thing to make sure the creditor gets paid because it's risky to bet all the money in the casino, that's not good for the company, that's your shield. When the shareholder says you should have gone to the casino, you go, no, I don't have to. And there's a case called Credit Line A, which talks about this in the 90s. You have that business judgment to say, that was too risky. No one would do that if this was a single-owned corporation. They wouldn't hurt the creditors in that sense. But the sword question is complicated. Can the creditors sue if you do go to the casino? Can they sue for a breach of fiduciary duty? Here the court said, one, you have no special duty to creditors. You don't owe them any fiduciary duty. And that's true when you're solvent, when you're near insolvency, and when you're insolvent. You don't have a duty to the creditors. Now, you might have a contractual obligation, whatever the agreement says. You don't have a duty, fiduciary duty to them. However, when the company is actually insolvent, so now the company can't pay all its debts, the lenders, the creditors, are the residual lender. So they now have standing to enforce your duty to maximize the value of the corporation. So there's a nuance. You don't owe them a duty, but you still owe the corporation a duty. And once you're insolvent, they have standing to sue. Now, they don't have that standing to sue if you're $1 over solvency. Like this is the zone of insolvency. No, they can't sue until corporate firm's actually insolvent. So at that point, they'll sue. They can't say you should have benefited us rather than the shareholders, but they can say going to a casino is never the good idea to maximize the value of the corporation. You shouldn't have done that, and sue. That's what this case called Giwala from about 10 years ago says. You have that ability to sue, but they don't owe you a special duty. They owe the corporation. So then, and this really gets closer to what you all were talking about nominee directors, because it's been litigated in the lender context. Well, often lenders say, and this is true with privately held companies and some public held companies, but lenders say, I want someone on the board. I want in my agreements that it says I get to choose one of the directors. Yes. And that's okay. You can put that in the charter. You can say there'll be 6 directors, one of them chosen by a lender. Can that, now that director, everyone knows that director is chosen by the lender, and everyone knows it's chosen by the lender because it's supposed to do what the lender wants. So that's why the lender puts that in. But the law is, once they're a director, they think about everybody. And they think about the corporation as a whole. They can't favor the lender. But in reality, that's not how it plays out. And so there's a really interesting case called General Growth Properties. This is a bankruptcy case, and I know you haven't done a lot of bankruptcy. I'll give you kind of a little basics on it. The question was whether the board of a debtor, so this company is going into bankruptcy, that's part of a corporate group, can consider the interests of the whole group when making a decision to file a bankruptcy case. So what was going on, if you look at slide 15, there's an org chart here. This company, General Growth, it's a parent company, but it had all these solvent subsidiaries. Parent and the subsidiaries were properties. So just a company that owned them all. And all of those subsidiaries had secured creditors who had put someone on their board of directors. So if you look at slide 16, you see the unsecured creditors were owed money by the parent. The parent was insolvent. The parent was going to file for bankruptcy. That was going to allow them to stop paying creditors. The subsidiary, not insolvent, had a secured creditor, owed all the money to that one creditor who chose the board of directors. So in slide 17, you see that when the parent filed, they wanted all the subsidiary corporations to file as well. Now, most people thought if you're a director of a subsidiary, your duty is to maximize the value of that subsidiary, not the whole group. Therefore, you can't file for bankruptcy just because your parent is bankrupt, because that's benefiting them. And the truth was they wanted the subsidiaries in bankruptcy so the parent could use the cash. What the debtor did was, what the parent did was, they fired all of the directors. And they had the contracts weren't drafted perfectly so that the parent could oust all the creditors' directors, put in new directors, the directors filed for bankruptcy. And the litigation got a little weird because everyone says that the directors are supposed to do what's best for the company. But everyone knew that the creditors had chosen directors that would benefit them, and the new directors were chosen to benefit the parent, neither of which were going to benefit the actual corporation that was at stake. And so both of these directors were testifying. And if you look at one of the statements at trial by the creditor's side, this is slide 18, the director says, my understanding of the bankruptcy as it pertains to these borrowers is that there was an independent board member chosen by the lender who was meant to, at least from the lender's point of view, meant to prevent a bankruptcy filing, to make them bankruptcy remote, that such filings were not anticipated to happen. That was bad testimony. Because the court says, no, a director is supposed to do the best for the company. But everyone knew that was why they were there. But the flip side was, so was the new director. They were trying to benefit the parent. But that director testified better. They said something to the extent of, well, we knew that we might end up benefiting the parent or we might end up benefiting the sub. But we knew that we were going to do the thing that was best. And doing the thing that's best is kind of like your duty. So surprisingly, the court said, yeah, that's all fine. The filing goes through. But they, it was an unusual case because you weren't allowed to do what benefits the creditor because everyone said, no, you have to do what benefits the corporation, but you were allowed to benefit the parent. But it was, in this extremes case where, the testimony was good, and it would really make the bankruptcy go smoothly. And after the fact, everyone got paid. So it was like the right economic decision, even though legally questionable. It's a useful example, though, because it's like an exception that proves the rule to say you really can't perform your duties toward a particular person who chose you. At least not overtly, because the law says you're not supposed to, even though I'm a realist and say people do. I have one more example, but I know I'm a little over time, so because if you have questions, feel free to jump in, but I have one more really interesting case that brings all this kind of stuff to an interesting point. But are there any questions first?
So if students don't at the moment, I do have two questions, but kind of, everything that you're saying, I am completely able to follow up. So there is no immediate follow-up question to that. But I have two very interesting questions. One is that in your jurisdiction, can an independent director be also a nominee director and vice versa? Because in India, that's not possible. In India, if you are a nominee director, you cannot be an independent director. So we want to know if in the US that happens, because you did talk about it very briefly.
If you mean by nominee, because that phrase, I understand the phrase as you all use it, it doesn't come up as much in the US because I think the answer is it's okay to be an independent nominee. If you mean by the controlling shareholder, the creditor, the CEO put up a slate of directors and said, vote for these people, and they got elected, they can still be independent.
Okay.
So you don't have to be chosen by someone else. You don't have to be right. So as long as you're elected and you don't have a connection separate from the fact that they chose you, it's fine. In fact, in the really complicated, people always look at it a little odd in the derivative litigation. You choose a special committee of independent directors to decide if the shareholders can sue you, but you choose them. You choose the and it could be like you're accused of fraud. The shareholders are suing on behalf of the corporation against the CEO and chairman of the board, saying you committed fraud, and you say, great, I'm conflicted. Here's two independent directors. They're going to decide whether or not this should go forward. They can be chosen by you. Absolutely. Now, in that context only, the court worries a little bit. So the court says, but we, the court, can also say they're wrong about their decision about going forward with the lawsuit. But they're still independent. And in the controlling shareholder context, total independence. So I think that's your question is, you can pick the independent directors. They're still independent.
So just confirming, even if there is a particular faction, be it a controlling shareholder or a creditor or anyone else, which is appointing a director to take care of their interests somewhere indirectly or practically, so to speak, these people can still qualify as independent directors. So if a company has to appoint a minimum of 3 independent directors, these can very well be included in that count of 3.
Yeah, they can choose them. And again, this is what I was saying earlier. It goes to this. We assume they can't take their interest into account, and they won't, unless, and 20 years ago, I would have said, oh, it's totally fine unless they're getting paid. Today, the law has moved, if it was your cousin, your best friend for 50 years, there's the Oracle case I mentioned, which was again in the litigation context, but people think that that's language is now elsewhere. The court said they weren't independent because they were on the same faculty as some of the directors. There was some donations. It was Stanford was where the independent directors were from. But one of the other directors was from Stanford. There was some money donated to Stanford. The court said they're not independent, but it was nothing to do with the fact that they were chosen by the managers and conflicted directors. So yeah, the US is a little weird in that sense where we assume that you're not choosing them to do what you want because that's not what they're supposed to do. Therefore, as long as they're not actually conflicted, they're independent. And it comes up with the bank ones too. The banks choose those directors. Those directors are independent. The banks don't often choose their own employees because they want an independent director who can do stuff, but they choose someone they know will think about it the way they think about it. And last thing, there's an interesting case where one of the judges even says, well, if you wanted someone not conflicted who would nonetheless do what you want, you should have chosen like these people who that they always vote for shareholders or they always vote against shareholders. Like, there are people you can choose because you know how they're going to vote. That doesn't make them conflicted. They can still be independent. So yeah, that's absolutely right.
Thank you. Do we have time for more questions?
I have time, and I have one more example if you have time that I can give you.
Sure. I just have one last question from my end, again, slightly unrelated. which is that we have multiple committees, since you have mentioned committees and their role, especially while exercising the business judgment rule at the instance of the court. I was just wondering if you could just spend a minute explaining maybe, or just touching upon the name of the different kind of committees which are statutorily maybe there. Like for instance, in India, we have remuneration committee, stakeholder relationship committee, CSR committee, we have risk management committee. So we have different mandatory committees. So if we have something like that in the US, and also if non-directors can be members of that committee, or only directors can be.
So committees are interesting. So there's like an audit committee, which is generally will have. There will be a compensation committee.
Yeah.
And the reason you have a compensation committee is because the employee directors are always conflicted in compensation. So you need a committee of independent directors who aren't the CEO. And there's some interesting litigation about this with Facebook. But yeah, so you have committees that you like. The very common ones are audit and compensation. Then you have special committees for these transactions I was talking about. So in the Musk litigation, some of it was you should have used the committee for this, or you had a committee but you should have had a shareholder vote for it. So yes, there's lots of committees. They almost always have directors on them. The question has come up. There isn't a lot of litigation on, can you have non-directors present on the committee? Because it doesn't come up that often. But the norm is you pick two. If you have 7 directors, 2 of them are independent, 3 of them are independent. You always have a certain number if you're public because you put those folks on the committee, and they if it's an investigation, you might hire a law firm. But that's the norm, and I believe if you have no directors, there's a problem because the decision would have to then go up to the board, and that's problematic. And so basically, if you set up a committee and you want them to maintain their independence, you need directors on, and you need to give them the ability to make the decision. So let's say there's 7 board members, and there's 4 or 3 that are independent. If you create a committee, you have to say, we're going to do what they recommend because we're all conflicted, right? Or that's part of making it an effective committee. Now, you mentioned all those other committees. Those are not required. I think some firms have them, like a CSR committee. You don't need one of those under Delaware law or SEC law. You could certainly have one. A board could create one, but it's not required. The ones you see, like you really need, is an audit committee and a compensation.
Thank you.
So I'll do, just because it's very interesting, I'll do one last point, this other example where it gets particularly complicated. This is slide 19. So this is where all this stuff comes together. There's a big question of filing bankruptcy. So unlike in India, like you all have, I don't know if it's still suspended, but under the Indian bankruptcy law, it's active. It's a creditor in possession model.
Yes.
We have a debtor in possession model.
Yes.
And so a debtor in possession model gives a lot of power to management. And lenders don't like that.
Yeah.
And they worry that management's going to file for bankruptcy to get in the way of them collecting on debts that they should be able to collect on, and really to hold them up, which is, I believe, this problem is why India went with a different model, which gives the financial creditors power. So what creditors do is they try to make things bankruptcy remote, like in General Growth. But with a smaller company that's not publicly traded, there's an easier way to do it, and there's something called a golden share. So you could put a board member on, right, and say, you should vote against bankruptcy. Instead, is you create a dual class of shares, and you say, in order to file bankruptcy, the board of directors has to get a majority vote of common shares and preferred shares. Common shares are all the regular equity holders. And then you give the bank 1 preferred share, and that's the only preferred share. that takes the decision away from the board, gives it to the bank, the creditor, and allows them to veto a filing for bankruptcy. And so it's a more direct way to give that lender the control they wanted when they were appointing a director. But now you say, well, they can't appoint a director because that director has fiduciary duty. They'll just have a special share that gives them the ability to veto a filing. So under Delaware law, this is fine. This is like, you're allowed to do this. Bankruptcy courts have said, and federal courts of appeals have said, it's also fine under bankruptcy. They've said you're allowed to create these shares and stop someone from filing for bankruptcy. This is very controversial because bankruptcy in the U.S. is supposed to be available to all firms that have creditors. And now you've given one creditor a veto. One question that we started is, does that creditor now become a controlling shareholder because they have one share that allows them to determine what happens? And if you go back to that quote when I said you can prove either that they control the board in this one transaction or generally, this looks like they're now a shareholder that controls everything with regard to the transaction of filing for bankruptcy, which you think would give them duties beyond their own self-interest. The courts have said no. They've said as long as they have that share and they're trying to maximize the value of that share, they can do whatever they want when voting on whether the firm files for bankruptcy. So they have this effective veto. So it's a way that now you don't have a nominee director doing what the person wanted. You have a share that gives that group that would otherwise nominate a director power over certain decisions. And what I've always been curious of, why have people only done this with bankruptcy? You could theoretically do this with everything to give one share. Now, you see a little bit of it in the dual class shares where, you know, Mark Zuckerberg or the owners of Snap, they all have the decision power. But you could imagine even in a company that was not concentrated ownership, where they just give banks a preferred share over this decision, preferred share over that decision. And I don't know, I think at some point there'd be pushback. So that was an example. It's a very fascinating and interesting area of how this all comes into play. The last thing I'll say, if you look at slide 21 on the new version, all of what I said up to now was about corporations. In the US, we also have LLCs, these limited liability companies. And the Delaware law about LLCs is, the default is they are run like corporations. But you can change anything you want. You can waive fiduciary duties. You can say that only the bank decides and they can be conflicted. You can have a presumption of no conflict. So that gives you a lot of freedom. And here's where I think, you can't be an LLC with thousands of shareholders, like Apple can't be an LLC. But if you had 10 shareholders, you could. And so if company, for kind of closely held companies, the LLC gives them total freedom. And I think some firms in India and the UK that are corporations would, I don't know the LLC law in India, but I would imagine if they were US companies, they would be LLCs and have a lot more freedom from the default rules than a corporation does. But again, you can't do it with widely held firms, but if you have a small number of shareholders, you can do it. So that was all my slides. I apologize again for the kind of hiccup at the beginning, but that's my presentation. Other questions?
Thank you so much, Professor. Just a small remark. We do have LLPs, limited liability partnerships. Yes, and a separate act for that. And actually, the corporate governance issues in LLPs is not such an issue that is widely read. In India, when we talk about corporate governance, etc., we just mostly talk about the companies under the Companies Act. So governance in other kind of organizations such as LLPs or even in other forms like trusts, etc., is not something that we have started studying as much as of now. So thank you so much for bringing in that point. Yes.
The U.S. has LLPs, and for a while, that's it. The LLC is, the best way to describe it is it's an LLP with the tax benefits of a corporation. And so it's a way, it became a way in the 90s that you could kind of get the freedom, liability, and the tax benefit all kind of together. So I said it backwards. It's the limited liability of a partnership, of a corporation, and the tax benefit of a partnership. But it's better than it's different than an LLP because it can be much larger, and you don't need the general partner. So it looks almost exactly like a corporation with all the benefits of an LLP. Is a better way to say it.
Thank you so much. Thank you so much. Does anybody else have any question? We would take your recorded lecture as a point of reference, and I would explain on a few points in the next lecture. I actually have just one last question, which is that you talked about independence and how the criteria for independence has been evolving, has been changing. So how there can be friendship associations and that can affect the independence of a person. So do you think law can take care of something like that, something like softer factors like that? And what is your suggestion in that regard?
You know, it's interesting because throughout I said, you know, in reality, right, there's all this stuff where the law assumes one thing, but we all know the other.
हाँ बताइए.
So it, you know, I think
भैया
the
2 मिनट
law
रुक जाया
can
कीजिए, आप मेरे
guide a
टाइम से
little
तो नहीं
bit,
आए, मतलब आपकी भी
but
गलती नहीं है, लेकिन थोड़ा
I
रुक
think it'd be
जाइए.
naive
मेरे को
to
बस 5 मिनट
say
दीजिए, मेरी क्लास खत्म हो रही है, ठीक है?
we will ever have a conflict-free kind of set of board of
भैया आप
directors.
थोड़ा रुकिए,
What the
अब मैं
law
क्या
can
करूँ?
do is
थोड़ा
say
रुकिए,
certain
बस मैं आ रही
things
हूँ,
are
ठीक है?
just too far,
मैं आ रही हूँ.
and you know that's the, you know, you've known him for
बस
30
थोड़ा
years,
रुकिए,
you've
मैं
named
आ
a
रही हूँ.
building after him. You know, it's kind of surprising now to say that wasn't the rule before, but you know, so those are easy cases. The harder cases are, you know, you've been a business associate with this person for years, and there's after Oracle, there's a case with Martha Stewart where the plaintiffs try to argue that she's done way too much. It's Martha Stewart Corporation. It was involved with her insider trading, and then the shareholders sued. And one of the directors was a banker who had done business with her for years. And the court said, you haven't shown a conflict. And I think that's the right outcome, probably. But you know, there might have been a conflict. It was just like they said, we got to draw the line somewhere, and they said that wasn't enough. And so I guess the answer to your question is it can if you have really good judges, because these are standards. These are like judges saying, is it too close, is it not? I always worry with standards because you could get bad judges or judges that just don't understand what the relationships are like. They might over enforce or under enforce. But I don't know that there's a good other solution unless you said, you know, you have to have outsiders, complete outsiders you never known. And one of the Judge Easterbrook, who used to be a professor at University of Chicago, he would always say the problem with independent directors is to get a really good independent director, you have to find someone who knows nothing about the business. Because if you're a telephone company, like if you're AT&T, you're not going to put Verizon on your board because that'll create antitrust problems. You're not going to put anyone at AT&T is not independent, and so the further you get from the business, the more independence you get, but the less useful they are at overseeing the operations. And you know, there's endless empirical literature about do independent directors add value or subtract value. I think most of the literature points to adding value, but you can see why if you get too independent, it becomes problematic. So as is a long way of saying there's no perfect solution. I think the law is probably doing the best it can, but you know, there's always going to be little conflicts.
Thank you so much, Professor, for your time. In fact, for giving more time than was even suggested. Very kind of you, very generous of you, and very passionate about what you were teaching. Thank you so much. I hope students understood different percentages because they come from different backgrounds, so their background knowledge was varied in that sense. But whatever they understood, because I thoroughly enjoyed it, and these are my notes, like 3-page notes that I was making totally engrossed. So thank you so much for the session, and I'm so glad that you came. And students, with your permission, Professor, can I just click a small photo for our memories?
Yeah.
Sure. Thank you. So very sweet of you. Students, can you please turn on